All right, folks, we have a huge deal tomorrow. The United States Supreme Court is going to be hearing oral argument in the VanDerStok versus ATF Department of Justice case against Merrick Garland, where the ATF has tried to expand through regulations, not by going through Congress, but by regulations, the definition of what constitutes a firearm under federal law. This is a very big deal of an attempt by the ATF to expand its jurisdiction and authority over you, the American gun owner. Let's break it all down when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Israel Disarmed, What the 10/7 Attacks on Israel Teach Americans About the Right to Bear Arms. Today we're remembering the victims of that attack, but we should also remember how that went down, which is by Israel not doing enough to encourage private gun ownership and a self-defense oriented gun culture. The Israelis became too complacent on government to protect them, with tragic, terrible consequences on October 7th, 2023. We'll talk more about that in a future video. But for today, we need to talk about tomorrow's United States Supreme Court argument in VanDerStok versus Merrick Garland, the Department of Justice, and of course the ATF. All one and the same. What has happened here, as you may recall, is an attempt to regulate so-called ghost guns, which is a political propaganda term brought about by the left. And as you know, the left is very good at naming things. Anything that's an unserialized firearm, including firearms that had serial numbers on there by a major manufacturer or an FFL, and then scratched off, obliterated, if you will, by criminals, somehow has become an unserialized gun and thus a ghost gun. Now, what's really going on here is that the ATF wanted to expand their jurisdiction to force more companies and people to go out and get federal firearms licenses, which gives the ATF authority over those people. And the ATF wanted to expand its authority over American gun owners and the acquisitions of firearms and firearm parts by those same gun owners by forcing them to go through a NICS background check system and fill out the Form 4473, which doesn't just include your name and information, but includes the make and the model and the information about what object you're acquiring. Now, the ATF knew they could not get this authority, and the Biden administration knew they could not get this authority with Kamala Harris in charge by going through Congress. So what they tried to do is what this Biden-Harris administration has been doing for almost 4 years now, which is to try to expand the scope of their authority by and through executive order and regulations, and that's exactly what they did here. Now, we're going to have to get a little geeky in this video, but I'm going to break it down. You're going to totally understand the details in a way that you're not going to get in any of the major newspapers. So again, just consult, come on back here to the video, ask me questions. We'll get to the bottom of this. You can skip over a lot of the mainstream media stuff. You can read it if you want, but, they're not going to be as accurate or as good as I am, as my guess. Okay, so with that said, let's break it down because we've got to be a little geeky here. To begin with, we have to start with the statutory definition of firearm as given to us by Congress. Congress enacted the Gun Control Act of 1968, and there's a very specific definition of what is a firearm. And again, the reason why the definition of firearm is so important is because if you're in the business of selling firearms, you have to have an FFL and get a gun license. And if you're buying firearms from an FFL, you of course have to go through the background check. So by expanding the definition of firearm beyond what it has always been understood for the last 5 decades, the Biden administration had many goals, including to expand its authority over gun owners and the gun companies and over companies that are not gun companies because they simply sold gun parts. Specifically, they wanted to target people that were selling what are known to be partially completed frames or receivers, meaning things that are not frames and they're not receivers, but at some point could be converted into a frame or receiver. And the Biden administration wanted to expand the scope of their authority without consulting Congress, without enacting legislation, which they know they could not get through, to encompass what are known as weapon parts kits, which by definition are parts kits, right? Now, this was the attempt, what they tried to do. And they did this in various ways. Now, they did this claiming that they needed to do this because of this great new danger to American society in the form of ghost guns, which is a propaganda term for privately made firearms. Because hobbyists would go out and acquire parts of these guns to make their own guns, and the government, meaning Biden and Harris, didn't like this because they want to know where all the guns are and all the gun owners are, because it makes it easier for them to confiscate, so they think. So where do we begin with analyzing this kind of complicated question? Well, we're going to make it pretty straightforward. We're going to start with what the statute, the Gun Control Act of 1968, defines as a firearm. Now, a firearm, at its most basic level under federal statutory law, is a weapon that fires or expels a projectile by means of an explosion. It's a weapon that expels a projectile by means of an explosion, or, here's the key, this is where the fight's going to take place, or the frame or the receiver of such a weapon. So part A is a firearm is a weapon that can expel a projectile by virtue of an explosion, or B, the frame or receiver of any such weapon. Okay? Now let me break down that first part a little bit more in more detail, because it's very important to understand this. Again, you got the definition of weapon and then or frame or receiver of such a weapon. All right? Now, there's really actually three components of part A. What is a weapon that fires a projectile by virtue of an explosion? Three little parts. Got to understand, they're all independent, but they all work together. And you'll see what the ATF is trying to do with the sleight of hand. The first one is a weapon that will, I repeat, will expel a projectile by virtue of the explosion. That refers to a functional, actual working firearm. The language of the statute is a weapon that will expel the projectile by virtue of the explosion. The second related definition as part of what is a weapon is a weapon that is designed to, hear what I just said, is designed to expel a projectile by virtue of the explosion. Now this is designed to refers to what I would call a non-functional, functional, or a broken part firearm, meaning it is a firearm that is designed to be a firearm, but it has some broken part associated with it, like a broken firing pin. So again, you've got the will expel, which is a functional firearm. Then you've got it is designed to be a weapon that expels a projectile by virtue of an explosion. That is a firearm that's designed to be a firearm, but there's some part on it that's broken. Like again, a firing pin doesn't work. And now we get down to kind of the third part, which is the most important part to understand for the purposes of the VanDerStok case. That is, a weapon is a firearm. A weapon is a firearm if it can be, listen carefully, a weapon is a firearm if it can be readily convertible, readily converted into a weapon that will expel a projectile by virtue of the explosion. You see? So you've got the will expel, is designed to expel, and finally, and this is the language the ATF is trying to glom onto, is readily convertible, or it can be readily converted into a weapon that can expel a projectile by virtue of an explosion. That is in the first part of the statutory definition. And then the second part of the statutory definition is the frame or the receiver of such a weapon. Now what the ATF, and this is why you got to understand this, what the ATF is doing is this. That language in part A of the definition of what is a weapon, what is a firearm, that uses the frame is readily convertible or is readily converted into a weapon that fires. They're taking that language of readily convertible or can be readily converted. They're taking that phrase of readily converted or readily convertible, and they're cutting and pasting it into Part B of the statute to modify the words frame or receiver. This is absolutely not allowed as a very basic method of statutory interpretation that lawyers and judges do every day. They are taking the phrase is readily converted to or can be readily converted to expel a projectile by virtue of an explosion. They're taking that language, which exists in the first part of the definition of firearm, and they're cutting and pasting it into the second part of the definition of firearm where it does not already exist. In other words, the ATF is trying to rewrite the language of the statute through regulation by taking that phrase is readily convertible or can be readily converted to fire a projectile by virtue of the explosion, and they're putting that in frame or receiver so that they want the statute to be read by the justices of the Supreme Court as something that can be readily converted to be a frame or receiver, or is readily convertible to be a frame or receiver of such a weapon. But the phrase readily convertible does not modify and does not exist in the sentence it relates to frames or receivers. This is not appropriate. They're trying to rewrite the statute to cover not just frames or receivers of a weapon that it is designed to or will or can be readily converted to expel a projectile by virtue of an explosion, and they're taking that language about readily convertible and modifying a frame or receiver or something that can be readily converted to become a frame or receiver. This is not allowed under the statute, and it's never been the ATF's position. Because up until this date, up until this final rule from a couple years ago when Biden and Harris did this, a frame or receiver is a frame or receiver, meaning it actually functions as a frame or receiver. If an object requires additional drilling, additional machining, additional manipulation for it to become a frame or receiver, then by definition, it is not a frame or receiver until that additional work is done to it. And what's happening here is that for 50 years, the ATF looked at an object and said, today, as we sit here, is this object we're looking at a frame or receiver based on what it is today and the work that's already been done to it as of today? So they would look at the item today and look backwards in time, perhaps, to see, is this a frame or receiver, and what has been done to make it a frame or receiver as of this moment in time? But what Biden and Harris did with this new rule that's being challenged in the Supreme Court tomorrow is they're now saying to the Supreme Court, look, we think the better way of doing this, despite our 50 years of precedent, and despite the statutory language that does not talk about a frame or receiver or something that can be readily converted into a frame or receiver, which is not there in the statute, we think the better way to do it is what we have come up with in the last year or so, which is to look at the object and ask the following question. Going forward into the future, can this object be readily converted with additional work by experts at the ATF in a day or so into a functional frame or receiver? Now, this is hooey as a matter of statutory grounds, and it's also inconsistent with everything they've been doing for the last 50 years. And I want to mind you one additional point before we get into what we should be looking for during the argument, what would be good for us in the argument, what would be bad for us in the argument. I want to remind you of one thing. The ATF position in this case is absurd, just on its face, because they are literally telling the United States Supreme Court that there is a brand new phenomenon, so-called phenomenon, brand new, meaning the rise and proliferation of so-called ghost guns, which again is a propaganda term for privately made firearms or unserialized firearms. And because of this brand spanking new problem that America has never seen before, the ATF needed to redefine all this stuff. But here's the kicker. The ATF's position is internally inconsistent because they're saying there's a brand new problem that needs to be addressed. But then they're on the other side, talking out the other side of their mouth, and they're saying that in response to this brand new problem of ghost guns and the rise of ghost guns, what are they doing? They're trying to tell the Supreme Court, and that's what they're arguing to the Supreme Court, that they actually have not changed any of their definitions or any of their processes or procedures for how they assess what is a frame or receiver or what is a gun or not a gun. So they're literally saying in response to a brand new problem, we're doing exactly the same thing we've always done for the last 5 decades. This is utterly absurd and internally inconsistent. Why would you, to confront a brand new problem, make no changes? And the reason why they're trying to do this is because they know that if the Supreme Court agrees with the Second Amendment point of view, which is the ATF is literally redoing the definitions and redoing all their policies and procedures to expand the definition of firearm through regulation, then that is obviously something that they're not allowed to do under the law. That is something that the only people that could conceivably expand the definition of firearms in federal statutory law is Congress itself, and Congress did not do it. So how does the ATF do it? But the ATF is trying to persuade the Supreme Court that they've made no change in their interpretation of these definitions of firearms, despite the fact they're allegedly using this non-change to confront the new problem of ghost guns. Utterly insane. Now, let's talk about what to look for on Tuesday. The first thing to look for is who is the lawyer arguing for the United States government. If they trot out Elizabeth Proligar, the current Solicitor General of the United States, if they trot her out again, it's a sign that the Biden-Harris administration is taking this case extremely serious, and they're very worried about getting their butt kicked. If they trot out Elizabeth Proligar as the lawyer for the government, it's a sign that this is a huge case for them, and they're very nervous about losing it. So the first thing to look for is who is the lawyer that's going to do the argument for the Department of Justice. If it's Elizabeth Proligar, big sign that the Biden-Harris administration views this as a huge case that they're worried about. Otherwise, they would not bring out the A-team. They would bring out one of their other lawyers from the SG's office. So that's the first thing to look for. The second thing to look for is the questions from the justices. And this is let me tell you what we want to hear. Let me tell you what we don't want to hear. And by who, it doesn't matter what the liberals say. Meaning, if Justice Sotomayor, Justice Brown Jackson, Justice Kagan whine and complain about guns, that's not what we care about. We know they're going to do that. So that's not going to tell us anything if they're whining and complaining about guns in the Second Amendment. That's what we would expect. What we want to look for are the questions from the other 6 justices. And what we want them to be focused on is the statutory language. If they're asking lots and lots of questions about the statute, what it means, the language of it, the phrase readily convertible, how on earth do you take readily convertible and cut and paste it into a different part of the statute dealing with frames and receivers to read frames and receivers to include frames and receivers as well as items that could be readily converted into frames and receivers. If you see a lot of questions about the statutory language, that's extremely good news for our community. In contrast, if you hear a lot of discussions about line drawing, well, how much work has to be done on an object for it to become a frame or receiver? Is it 80%? How far along does that item have to be before it can be a frame or receiver? If you start hearing discussions of line drawn between what is a frame or receiver and what is not a frame or receiver, that as a general matter would be bad news as I see it, because now they're trying to draw a line here between what is a frame or receiver and how much work has to have been done on it, how much work will need to be done on it going forward, and how do we figure this out? If you hear a lot of questions about line drawing, that will, generally speaking, be a bad bit of information and bad news for the Second Amendment community. Okay? Now, the other thing to keep in mind is this. There are really 2 items that are at issue here. One item is, I think, should be a slam dunk win for us. The other should be a slam dunk win for us, but it's a little bit more complicated, and that is the weapon parts kit. On the frame or receiver issue, it should be a no-brainer that anything that in theory can be readily convertible into a frame or receiver, but it's not a frame or receiver now, really should be a slam dunk. Because again, as we've talked about on this channel before, looking at a kid on the playground that could become Tom Brady, he could become the president, he could become anything, doesn't make him so right now. Likewise, an object that could become a frame or receiver doesn't make it a frame or receiver right now. So, that I think should be a straightforward win for the Second Amendment, even though this is not a Second Amendment case per se. Obviously, it speaks to the gun issue, so it touches effectively on the right to keep and bear arms. Now, the closer call that's not that hard, but I would be a little bit more worried about the Supreme Court making a mistake on this, is dealing with these weapon parts kits. Now, just as a reminder, and I want you to pause for one moment, this is important, but once you hear it, you will never forget it, I don't believe. Think about it for one moment. If you have a set of parts in your grubby little hands in a bag that comes from some company, okay? If that bag of parts includes a frame or a receiver, it is a firearm. Hear what I just said? If a bag of parts that has within it a frame or a receiver, it is by definition a firearm under the statute, because the statute includes not just a weapon that can or will is designed to or can be readily converted to fire a projectile by virtue of an explosion, or a frame or receiver. If a bag of parts includes the frame or receiver, by definition, it's a frame or receiver, and you would have to go through the background check, and only FFLs can sell that in the course of their business. But if it does not, and this is the key, if it does not include a frame or receiver, it really is not a firearm, right? Because it's not designed to, and it cannot be readily converted into a firearm because it doesn't have a frame or receiver. So again, that is where the rubber is going to hit the road, and this is where I think the Cargill case involving bump stocks is very good for us, because if you remember there, you had an actual example, at least allegedly, of a mass shooter in Las Vegas using a bump stock, although there's a debate as to whether or not he used the bump stocks to fire the gun in Vegas, or he just had them in his hotel room. Not sure we know the answer there. But the bottom line is the Supreme Court actually had that example of somebody misusing a bump stock, and they still laser focused in on the definition of what is a machine gun and concluded that a bump stock attached to an ordinary semi-automatic firearms is not a machine gun. Okay? So if they're focused on weapon parts kits, there's two reasons, again, why a weapon parts kit is not a firearm. Assuming, of course, it doesn't have a receiver or frame. If it doesn't have a frame or receiver, well, obviously it's not a gun, because it's not designed to be a firearm. It will not expel projectiles with an explosion, and it's not readily converted into a weapon that can expel a projectile by virtue of an explosion. So those are the reasons why I think the weapons parts kits may be a little bit more complicated, but the right answer is because it doesn't include a frame or receiver, it's simply a amalgamation, if you will, a set of a constellation of random parts. And if it's just a bunch of parts without a frame or receiver, it cannot be a weapon that is designed to or that can readily be converted to expel a projectile by virtue of an explosion. And thus, since it's not a firearm, the ATF cannot regulate and require people to get a license to sell weapon parts kits, or you are not required, would not be required under federal law to undergo a NICS background check, because you're not acquiring a firearm or a frame or receiver of a firearm, which under the statutory language, a frame or receiver is a firearm as a matter of statutory interpretation. So anyway, folks, I know this is a little bit longer video, but I really wanted you to understand what to be watching for during this oral argument on Tuesday. Again, we want them to focus on the statutory language, where our side is very strong. If they start talking about policy considerations, they start using the words like evasion versus compliance. If they start dealing with policy considerations, that will be a bad sign. But again, based on the Cargill decision, I think the Supreme Court is very focused on doing the right thing by the law and what the law says. And again, they may say, look, this is a great idea. Go back and talk to Congress and get them to pass a law. But until you've done that, we're going to stick with what the federal statutory definition of firearms has been for 50 years. We're not going to let you go beyond that. And again, a frame or receiver is something that's an actual frame or receiver. Something that in theory could become a frame or receiver is not a frame or receiver. And therefore, something that could become a frame or receiver is not a firearm. And as a consequence, no NICS check is required and no FFL is required to sell it. That's where we want the Supreme Court to come out, and we will know a lot more, I suspect, after that oral argument on Tuesday. So there you have it, folks. Hope you learned something here today. Make sure you follow me on X at 4 Boxes Diner, and we will see you again very soon here at the 4 Boxes Diner.
Orders up. Table 2A.